There is a legal strategy so counterintuitive that most people reject it the moment they hear it. It involves voluntarily placing a lien on your own property. Not because you owe someone money, not because a creditor forced it. You do it yourself, intentionally through a structure you control, before anyone sues you, before any judgment is filed, and before any creditor has reason to look. When you are finished, the public records show that your assets are already encumbered, that someone else has a prior claim to your property, that there's nothing left for a plaintiff's attorney to take. The assets are there. You control them, you benefit from them. But from the outside, to a creditor searching for collectible assets, your balance sheet looks like a skeleton. There is nothing left to take because the most senior claimant in the priority stack is you. The strategy is called the friendly lien. The legal framework behind it is as old as secured lending itself. And the vehicle used to execute it is the same limited liability company that costs less than $100 to form in most states. You create a company. The company loans money to you, secured by your real estate, your business equipment, or any other asset you want to encumber. The loan is documented. The lien is filed publicly. And now, any creditor who obtains a judgment against you stands behind your own company in the priority of claims. Before they can touch your equity, they must satisfy the company's lien first. And the company is yours. You control both sides of the transaction. The court system does not prohibit this. It does not even look sideways at it. It simply applies lien priority rules that have governed commercial lending for over 2 centuries. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The legal principle underlying the friendly lien is one of the oldest in commercial law. Priority of claims is a foundational concept that determines the order in which creditors are paid when a debtor's assets are liquidated or collected. In American law, this principle traces directly to English common law and the Statute of Frauds of 1677, which required that certain security interests in land transfers be in writing to be enforceable. The principle was further developed in American courts through the 19th century as railroads, banks, and industrial companies developed complex capital structures involving multiple layers of secured and unsecured debt. The modern framework for secured transactions is Article 9 of the Uniform Commercial Code, which governs security interests in personal property. For real estate, state-specific lien and mortgage laws apply. In both systems, the fundamental rule is first in time, first in right. The creditor who perfects their security interest first, by recording the mortgage or filing the UCC financing statement, has the senior claim on the asset. Any creditor who comes later is subordinate. If the asset is worth less than all the claims against it, the junior creditors receive nothing until the senior creditor is paid in full. This priority system was designed to protect legitimate lenders, but it applies equally regardless of the relationship between the debtor and the creditor. A company you own can lend money to you personally. The loan can be secured by your real property, your business equipment, or your accounts receivable. The security interest can be perfected by recording a mortgage or filing a UCC financing statement. And once perfected, that interest has priority over any future judgment creditors, because those creditors come after the lien in the chronological priority stack. The wealthy have been using this structure for generations. Large family businesses routinely have complex intercompany lending arrangements, where operating companies owe money to holding companies, which owe money to family trusts, which owe money to various financial entities, all controlled by the same beneficial owners. The result is that any external creditor looking at a particular company in the structure finds it encumbered to its eyebrows. There is nothing left to take. The equity is buried under layers of legitimate, documented priority debt that all flows back to the same family. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete Friendly Lien Implementation Guide, LLC formation instructions, UCC financing statement filing procedures, promissory note templates, and the charging order protection comparison by state. The link is in the description, but stay right here. The key legal risk in a friendly lien strategy is the fraudulent transfer doctrine, also known as fraudulent conveyance law. This is the legal mechanism that allows courts to unwind transfers and liens that were created specifically to defraud existing creditors. The relevant federal law is the Uniform Fraudulent Transfer Act, adopted in most states, and the Bankruptcy Code's fraudulent transfer provisions in sections 548 and 544. Under these provisions, a transfer or lien can be voided if it was made with the actual intent to hinder, delay, or defraud any creditor, or if it was made for less than reasonably equivalent value when the debtor was insolvent or became insolvent as a result. The critical phrase is reasonably equivalent value. A friendly lien survives fraudulent transfer scrutiny when the lien is created in exchange for actual value. If your LLC lends you $250,000 and takes a mortgage on your property as security, the lien is supported by consideration, the actual loan proceeds. If the loan is documented with a proper promissory note at a market interest rate with a real repayment schedule, It is structured as an arm's-length commercial transaction. Courts in multiple jurisdictions have upheld legitimate intercompany loans secured by real property where the transaction was properly documented and supported by real economic substance. Timing is critical. A friendly lien established before any dispute, lawsuit, or creditor claim arises is dramatically stronger than one established after. The fraudulent transfer look-back period under most state laws is 4 years, and under the Bankruptcy Code, Section 548, it is 2 years for actually fraudulent transfers and 4 years under Section 544 using state law. Any lien created within these look-back periods, particularly shortly before a lawsuit is filed, will face intense scrutiny. The strongest friendly liens are established as part of a comprehensive asset protection plan implemented years before any legal threat emerges. If you have made it this far, you already understand the mechanics of lien priority better than most people who will face a judgment creditor without any protection in place. Subscribe and share this video. Now let me give you the practical steps. Step 1. Form a separate LLC. This entity will serve as the lender in the structure. It should be formed in a state with strong asset protection laws and charged with a legitimate business purpose. The LLC should have its own bank account and be maintained with proper corporate formalities. Step 2. The LLC loans you money. The amount of the loan should reflect a legitimate transaction. The funds should actually flow from the LLC to you. If you are funding the LLC with your own money first, that is acceptable, but the economic substance must be real. The LLC can be funded by your business profits over time, by contribution from retirement funds, or by other legitimate means. Step 3. Document the loan with a formal promissory note. The note should specify the principal amount, the interest rate, which should be at or near the applicable federal rate published monthly by the IRS, the repayment schedule, and the consequences of default. Step 4. Secure the loan with a mortgage on your real property. The mortgage must be executed, notarized, and recorded at the county recorder's office to be perfected. For personal property, file a UCC financing statement with the Secretary of State. Step 5. Make actual loan payments from you to the LLC according to the promissory note schedule. These payments create an ongoing record of the genuine commercial nature of the transaction. Step 6. Work with a qualified asset protection attorney to review the structure annually and ensure it remains compliant with any changes in fraudulent transfer law or state statutes. The total cost of implementation includes LLC formation fees of $50 to $500 depending on the state, legal fees for promissory note and mortgage drafting of $500 to $2,000, and recording fees at the county level of $20 to $100. Ongoing costs include payroll service or accounting for the LLC and annual state filing fees. I need to be honest with you. This strategy carries meaningful risks and limitations. First, it must be implemented before any legal threat arises. A friendly lien created in response to an existing lawsuit or a known creditor dispute is almost certainly a fraudulent transfer and can be voided by a court, leaving you worse off than if you had done nothing. Second, the loan must have real economic substance. A lien that is not supported by actual loan proceeds, a documented repayment obligation, and genuine interest payments is a sham and will be treated as such in litigation. Third, some states are more aggressive than others in challenging intra-company liens. California and New York courts have a history of scrutinizing related party transactions more carefully than states with more debtor-friendly laws. Fourth, a bankruptcy filing changes the analysis significantly. The bankruptcy trustee has powerful tools to unwind pre-bankruptcy transfers and liens, particularly those established within the look-back period. If bankruptcy is on the horizon, this strategy may provide little protection. And fifth, the charging order protection that makes LLC interests difficult for outside creditors to seize applies differently in different states. Wyoming, Nevada, and Delaware offer the strongest charging order protection. Some states offer very limited protection, meaning a creditor could potentially obtain a charging order that gives them the right to your distributions and eventually foreclose on your membership interest. Your grandparents who owned farmland understood intuitively that what you owe matters as much as what you own. They mortgaged land to family members. They held notes between relatives. They structured things so that in a bad year, the bank was not the first one through the door. The strategy was not deceptive, it was structural. It used the rules of priority and documentation that governed everyone equally. Then one generation was told that having assets meant having exposure, that owning things meant owing nothing to anyone who came to collect. They forgot that the rules of priority apply to everyone, including yourself. There was not a safer structure. There was just an informed one. Subscribe and share this video. Every share teaches one more person how to stand at the front of their own priority stack. The next vault opens soon, and what is inside involves a single-page letter that costs less than $10 to send and is so legally powerful that debt collectors are prohibited by federal law from contacting you again after they receive it.